crack on, perhaps I can just ask the members if there are any declarations of interest they may wish to register. Nurse.
Thank you, Chair. I would like everybody to know my members' interest, and also I was previously the Maritime Minister as well.
Thank you. Chris.
Mr. Chairman, I'd like the committee to know that I'm a former member of the RMT Union.
Thanks, Chair. I'm a member of the RMT Parliamentary Group, and for a number of years I've known Mick Lynch, and I did have meetings on Monday with some of the sacked and victimised seafarers, and with from the RMT, and with Nautilus International.
Actually, as did I, so I should also raise that interest. I was there with you at the time, Graham.
I'm also declaring my membership of the RMT Parliamentary Group, and again, I've had meetings with Nautilus and with RMT over this issue.
Excellent. Okay, I think we've all remembered that we've been meeting with the RMT on that basis. Right, okay, for reasons known to my clerk, I need to swap the chair over to Darren Jones, who's going to take us through the first 4 panels. Darren.
Oh, yeah.
Thank you, Hugh. Good morning, everybody. So our first panel, we're delighted to welcome on the screen Professor Alan Bogg from the University of Bristol and Professor Jason Chu from City Law School, and in the room, Andrew Burns, QC. Good morning to all three of you. First question, please, from Simon Jupp.
Thank you, Chair. Much appreciated. The key question, I think, with this session is what P&O Ferries have done, is it legal in this country? And Andrew, if I can come to you first.
The law requires any employer that is contemplating making redundancies on a large scale to give two things. First, to give notice to the Secretary of State, and second, to consult with the appropriate representatives. There is a specific provision for employers who have employees on ships that are flagged in other countries apart from the United Kingdom, and that is that 45 days before the first dismissal, the company must give notice to the appropriate country where the authority in the country where the ship is flagged. So there are two matters. I can't say whether or not what's happened is legal or not, because I'm not instructed on any of the cases. I don't know the exact facts. I know I've been broadly told, and so obviously what I say comes with that caveat. But in broad terms, all employers with ships must give a notice to the appropriate authority 45 days before the first dismissal. And my understanding from what I've been told this morning is that the notice was given to the appropriate authorities in the countries where the ships were flagged only on the day of the dismissals and not in advance. That appears to be a breach of section 193A, and potentially 194, which is the provision which means that there's unlimited fine for a failure to notify the Secretary of State. And if 194 is looked at in the light of 193A, the amendments which are made for companies which have ships flagged overseas, then it may be that they are liable to a prosecution. The second point is that they are indeed potentially liable for claims to be made for protective awards of up to 90 days pay from all of the 800 employees who were made redundant without the notice going to their appropriate representatives, in this case I suspect the RMT union, and for consultation. And the law says, it's quite clear, and it's abided by, in my experience, in the vast majority of cases, which is why the circumstances we are facing today are so unusual. Employers will, at least 45 days before the first dismissal, and normally before that, because the obligation is to do it in good time, when redundancies are first proposed by the management of the company, they must provide in writing to the union or the appropriate representatives some statutory information. And that is done, in my experience, in the vast majority of cases. And also, HR1s are supplied in the vast majority of cases. I only know of one other case where an HR1 was not supplied, and that was a CityLink case where the company effectively was on the brink of collapse on the 22nd of December, and I think didn't collapse until Christmas Eve, and the HR1 was served on Boxing Day. So very different circumstances to this. But I think that's the only previous prosecution that I know about. So I can't tell you whether this particular case was lawful or not, but that's the context of two of the broad matters. Plainly, other legalities involved. Were the workers sacked fairly or unfairly? They may have individual claims for unfair dismissal. Is there a transfer of undertaking between P&O Ferries and the new company which is supplying the agency workers? Potentially there might be. There's a potentially even maybe discrimination if there is a nationality element to who was dismissed and who was not dismissed. There's a number of different options. This appears to be a case which engages quite a number of the employment law rights that people who are employed in the United Kingdom are subject to.
Thank you for that very fulsome answer. I just want to understand really, so you can explain to the committee and those watching, to what extent this matter is a matter for UK law, international law, because actually this practice has been done before. You know, we'll talk about flagging later on in this session, but this practice is commonplace, but not on this scale. So is this a bit of a grey area between UK and international law?
There will always be a dividing line between the extent to which UK employment law can intervene in a person who is employed not entirely within the UK. And there's a body of case law about people who are employed in different countries but are based here or have attachment here. And there is Parliament has decided not to legislate specifically to say who is and who is out of UK employment law, but leave it to the courts. And the courts have filled that gap by putting together a body of case law to say who is ordinarily working in, it's actually Great Britain is the language that's used rather than the United Kingdom. And the difficulty comes that the different provisions of employment law sometimes have different jurisdictional limits. So, for instance, national minimum wage applies if you are ordinarily working in the United Kingdom, and that doesn't apply to territorial waters, doesn't apply to international waters, but it would apply when you're working in your port, at your base, for instance. So one thing that the committee could consider is whether or not it's important now for Parliament to fill that gap that has been filled by the courts up until now and legislate more particularly about who is covered by UK employment law and who is not.
Just on that point then, on the UK employment law, there's been an awful lot on social media regarding the concept that this and what P&O have done was only possible because of Brexit or the fact that fire and rehire legislation wasn't agreed to by Parliament in the last couple of months. Is there any truth in that?
Fire and rehire legislation is irrelevant to this because what P&O have decided to do is not what many employers would have done, which is say to the employees, will you change your terms in order to make us more commercially viable, and then go into negotiations with the employees and their unions to decide whether or not. And that has been done successfully. It's been hard, but Centrica, British Airways over the last couple of years, they came in for a lot of flack, but they successfully consulted with unions and they reached, for all or most of their employees, deals for doing that process. So certainly there is that example that it does work, has worked on many occasions. It's very unusual for a company not to attempt it at all, in my experience.
And you talked about how some of the legal implications of this. What steps could the government take at this stage to do something about this retrospectively now?
I should say I've probably been dominating the conversation. I wonder whether
I will open it up in a moment, don't worry. But what would, in your mind, be the steps the government could take at this stage?
When the first thing that a union or employees know about dismissal is being told that it's happening now, it's quite difficult for the courts to intervene because the courts generally won't grant an injunction to force somebody to employ workers and have an active employment relationship with them. There are some cases in which employers are forced to keep employees on the books whilst a disciplinary process is gone through. And there's been a recent case involving Tesco in which courts have unusually said that dismissals in order to re-engage on lesser terms was unlawful and could be subject to an injunction. But generally, although fire and rehire has been much criticised by politicians and others, it is subject to reasonableness. And it may be that the reason that it didn't happen in this case is that a view was taken that it wouldn't be reasonable in these circumstances to fire and rehire, because you can only fire and rehire lawfully if an employment tribunal finds that it would be reasonable to do so. And that is a huge break on fire and rehire, because, and new legislation, I think, my personal view is that that doesn't help, because we've already got the reasonableness test. And the reason that employers do think very hard and long before they do fire and rehire is because the penalties for getting it wrong are financially very significant. And reasonableness is a very good test, because if it's reasonable to fire and rehire, why should it not be lawful to do so?
Thank you. I'll open it up to Alan and Jason, if I may. Some of the points that have been covered, specifically around your interpretation of whether P&O have acted legally in this case. Alan, if I can come to you first.
Yeah, thank you. So I'd as a lawyer, I'd add the same caveats as Andrew has added. So I'm not familiar with the detail of the facts, and before I came to a conclusive view, I would need to understand exactly what happened and be privy to the contracts and the timeframes. But on what I know, there's absolutely, I'm going to say no doubt, that wouldn't be true. There's very little doubt in my mind that what has occurred involves multiple breaches of labour legislation. So the collective redundancy provisions, unfair dismissal, perhaps discrimination law, and I could go on. So I think in legal terms, what happened was so blatant and so outrageous that there can be very little argument about whether the law covered it. The key issue is an issue of remedies and a lack of effective remedies in situations of this nature. And for me, that should be the focus for the government as it now looks at P&O within the wider context of an enforcement crisis in UK employment law.
Jason, anything you'd like to add to that?
So take an example of a breach of collective redundancy procedure. So there is actually a penal award for that, and that's leaving aside the possible criminal penalties, which may be more controversial. But for breach of the consultation procedure, there is the protective award, which is extensive. It's capped at 90 days. But there's no limit on weekly pay for that purpose. So it can be quite a significant financial remedy. But for a company with the financial heft of P&O, the fact is there is a cap on the protective award. The employer can calculate in advance what its financial liabilities will be, and it can then effectively buy itself out of the rule of law by offering compensation packages that go beyond what the legal remedies would be. So I think in this kind of situation, I would be in favour of removing caps and limitations on remedies in situations where you have such a gross violation of employment laws as you have here, because it removes the possibility of efficient breach, which is an affront to the rule of law. It's effectively buying out of the legal system.
Jason, is there anything you'd like to add to Alan and Andrew's testimony so far?
Thank you. Can you hear me?
We can hear you loud and clear.
Perfect, thank you. I should add a health warning to what I'm about to comment on. Obviously, I'm a maritime lawyer, so I'm going to be focusing largely on the seafarers side of things rather than employment rights in general. So the questions raised concern, I think, number one, legality of what P&O Ferries have done, and number two, what can be done as far as the government is concerned, or any other stakeholders. So I think as far as legality is concerned, Andrew was quite right to say that notice has to be given, and that actually was a change to our previous law following the Seafarers Directive from the European Union. So that essentially meant that the duty to notify the Secretary of State, which was published in law before, had to give way to a duty to notify the place where the ship was registered. And there are three places where the ships were registered: Cyprus, Bermuda, and the Bahamas. So it is a 45-day period notice for Cypriot registered vessels. It is 30 days for Bermuda and for the Bahamas. Now, as to what the consequences are, I think I'm not an employment lawyer, so I have to stress that. But amongst the shipping circles, there is some concern or some, I suppose, some troubling thought as to whether that the failure to notify the ship registries in these different jurisdictions actually would attract a penalty, because the relevant section actually simply refers to the duty to notify or the failure to notify Secretary of State. It doesn't actually refer to a failure to notify the flag state. And so we are a little bit unsure as to whether the failure to notify within those set parameters would attract any kind of sanctions under the Trade Unions and Labour Relations Act. So that's one aspect of, I think, the discussion that has been going on so far. So back to your secondary question earlier about to what extent has Brexit got to do with this? To some extent, I suppose one could say that the dispensation of the requirement to notify the Secretary of State was actually introduced by EU law, and that has been kept as retained EU law. But of course, with Brexit, it is now possible for Parliament, if it so desires, to change that and move it back to a duty to notify the Secretary of State rather than the flag states registries. So maybe I should pause there and see if there is any follow-up question, and then I could move on to other aspects of seafaring.
I think what I'll do, and hopefully some of your questions will be answered later in this session, is I'll hand over to my colleague Nusrat Ghani.
Thank you so much. So it's been made clear that their obligations, because of where they were flagged, would have been to the states where they were flagged. But Professor Bog, you talked about the multiple breaches in managing the way that the employees were dismissed, and you talked about what can take place next. And I wondered if you thought there was any support for the idea that theoretically, because of the multiple breaches that you've spoken about, there could be a way of seeking an injunction restraining P&O from breaching UK employment law. I know injunctions are very rarely granted, but because there are so many people involved, employees, 800, and there seem to be quite a few breaches in UK employment law, and how you explain or conduct a consultation, how a redundancy could take place. What do you think, Professor Bog? Could there be an injunction?
Thank you very much for that question. So it's possible for there to be an injunction in circumstances like this, but it would depend upon what was in the individual contracts of employment and whether there were specific procedures that have been incorporated from a collective agreement into the individual contract. Now, that can sometimes be difficult because collective procedures, as the courts would say, are not apt for incorporation sometimes. So at the current time, I think it's very difficult to give a definitive answer. What I can say is that there are obstacles to seeking injunctive relief. But if I may say, I think that provides another argument in favour of statutory reform to give provision in a case of this nature to freestanding interim relief under the statute. So what you would say is you don't need to look at the contract, you simply identify and anticipate a breach of the statutory consultation procedure, and the statute then gives an option for interim relief, which is what you have in trade union dismissal cases. So it's possible to go to the court to get interim relief to keep the contracts on a footing until the issue has been considered by the court. So I think it's possible, but there are difficulties. But in terms of reform priorities, I absolutely think that this should be something to be considered. And also in the fire and rehire bill, in the detail of that bill, my recollection is that there was provision in clause 2 of the Barry Gardner bill for injunctive relief in situations where fire and rehire was in breach of procedure. So there's no question this isn't a fire and rehire situation, but this is fire and rehire on steroids. These are things that are on the same spectrum of contractual deregulation. So I think what I would push back at Andrew by saying is that the failure to deal with fire and rehire has set a broader tone about the seriousness with which Parliament takes enforcement, and that I think can encourage a culture of impunity, which is maybe what we've seen here.
Thank you, Professor Bog. Because this is an extraordinary situation, one could then apply extraordinary responses, which could then theoretically be an injunction. My next question, I'll keep it short. I do need super short answers, I'm afraid. And I'll go to Andrew yourself first. In legal terms, has P&O adequately demonstrated a business need to reduce staff numbers? And if they had, what would that look like?
My understanding, they aren't reducing staff numbers. They are contracting out and having the same number of staff, but rather than being employed in-house by P&O Ferries, being contracted in from an external company. And we all know that many, many companies have found it commercially advantageous to, rather than employ their own staff, to contract in from third parties that provide that staff. This is, I think, unusual to do it to this scale, but what makes this case unusual is not contracting out, but contracting out with no notice and telling everybody on the day. And the reason it's here is because this almost never happens. And the reason it almost never happens is that we do have really serious financial penalties, compensatory penalties, for employers who don't follow the rules about notification and consultation. And so one thing I would say is that although there might be a knee-jerk reaction to the law needs to change to stop this happening, we obviously need to consider that it happens really, really infrequently because the present legal system does impose really, really significant financial penalties against employers that don't give any notice at all.
Thank you. I think my time has run out. Thank you, Chairman.
Thank you. Just two very quick wash-up questions from me. Mr. Burns, it's been suggested that P&O Ferries might say that their contracts of employment are based in Jersey and that leadership in Jersey made the decision to make the staff redundant. If that was the case, does UK law bite?
UK law, yes, can bite because the employment tribunals don't look just at what the contract says. The employment tribunals look at the reality of the situation. They look at where employees are based in reality, and that's often looked at where they're assigned to. So if the employees in this case had bases in Dover or Hull or places like that, where they checked in, where they were managed, where their employment was administered from, there is a real likelihood that UK law and the employment tribunal's jurisdiction will apply to them. Whereas somebody who's based overseas, where they're managed overseas, where they're paid overseas, where they're taxed overseas, And what the Employment Tribunal does is look at a range, a package of factors to see whether or not UK employment law has the closest connection to their employment. So the fact that the employer is based, has an office overseas, or the contract which says this is subject to a different law, isn't the factor which wins.
Thank you. And Professor Chu, if P&O Ferries didn't adequately notify the Cypriot, Bermuda or Bahamian competent authorities within sufficient time, is that a breach of UK law?
According to the Trade Unions and Labour Relations Act, it would be a breach of UK law because it is quite plain in that statute that they need to notify these flagged state registries. However, as I was saying earlier, there may be a question as to what the penalties may be, because the penalty provision relating to notice doesn't actually specify this particular seafaring category, and that is perhaps a gap in the law which could be plugged, hopefully in the future.
Thank you. Hugh Merriman.
Thank you, Chair. Andrew, perhaps I'll put this to you because you raised it. The Prime Minister said that the government will ensure that mariners working in UK waters are paid the living wage. Is that a matter solely for Parliament to legislate, to cause that to occur, or are there international obligations in maritime you're aware of that could cause that to be impossible?
National minimum wage is domestic legislation. It's unrelated to our membership of the EU. It was something we put in domestically, and we can enforce that as long as there's a connection between the companies and the employees in the UK. We plainly can't say that somebody who's employed at the other side of the world by a company on the other side of the world should be paid a certain amount of money. That's obviously ridiculous. But if there's a connection with the UK, it seems to me that we could legislate to potentially make the national minimum wage apply to, let's say, UK territorial waters. At the moment, the legislation says it doesn't.
So my understanding is at the moment you would be able to enforce the national minimum wage between, say, ferries going to Scotland, Northern Ireland, but not between Dover and Calais. But you believe there should be a way for Parliament to make that happen?
Parliament could amend the legislation in relation to seafarers, which there are specific provisions in relation to the minimum wage for seafarers on UK flagships and seafarers on non-UK flagships. And at the moment, the national minimum wage applies to the time when they're ordinarily in Great Britain or they're based here. So when they're on shore and doing their preparation and so forth. But I think as soon as they go into waters, I think Parliament's chosen that the national minimum wage shouldn't apply to them at that point.
Sorry, last part. So bizarrely, it could be that if you're going from Dover to Calais, the time that you are in the English waters on that strait, you could actually apply the minimum wage then for that part. I'm sure hopefully the French would do the same with their minimum wage on the other side.
At the moment, I think that and I haven't looked at this in real detail, but I think that the national minimum wage will only apply while they're in port.
May I come in on that? I apologise. I've done a bit of work around the minimum wage for seafarers within territorial waters and continental shelf. So the national minimum wage for offshore employment order was amended in 2020. And so that now places the requirement to pay national minimum wage for anyone who works or ordinarily works in UK territorial waters or in the UK sector of the continental shelf. So this means that if we had a seafarer working on a vessel which is sailing from Northern Ireland to Scotland, they will be covered by the national minimum wage. But if we were sailing from England to Ireland, then we would hit a non-continental shelf waters, then it raises a question as to whether that seafarer would be covered by the amendment introduced in 2020. So this is an anomaly which I know that Parliament had deliberated over previously in 2020.
Professor Chu, sorry to interrupt, but I'm very conscious of time. If you could write to us with the detail of that, we'd be very grateful. But I've got one very last quick question on this panel from Ben Bradshaw.
Professor Bogg, just very briefly, are there any significant differences in French and Dutch labour law which have led to P&O not treating those workers in the same way?
I think that the position in both of those jurisdictions would be that there are more significant restrictions in place for failures to consult of this kind, and the difference would be in the remedies and enforcement, and the possibility that dismissals might be amenable to an injunction, or might even be null and void because they've been undertaken in breach of procedures.
If you could write to us with a bit more detail on that, I think we'd be very grateful.
Yeah.
Of course, one very quick point, if I may. I would emphasise.
I'm sorry to cut it off, Professor Bogg, but I've got 5 panels of witnesses to get through. But you're very welcome to write to us, and we'd be very grateful.
I'll send you a note.
Thank you so much. I'm grateful. Thank you to our 3 witnesses for our first panel. We're now going to move swiftly on to panel 2 with representatives from the trade unions. We have Mark Dickinson, who's the General Secretary from Nautilus International, and Mike Lynch, who's the General Secretary of the RMT. We'll just let you take your seats. Thank you. Good morning to both you gentlemen. Thank you for coming in at short notice. The first questions are from Alan Brown, please.
Thanks, Chair. Just quickly to Mick. I've seen a response from P&O Ferries back to the Bees Department, where they argue that when they done the notification on the day, they did do personal notification to seafarers that were on the ships rather than the reported Zoom or pre-recorded messages. Is that right, or is P&O at it with that?
My understanding is that the vast majority of our members heard about this via video, via this Zoom call. Other members who were obviously rostered off got all sorts of communications, couriers, postal services, but I mean, if you're not in the house, you don't get the message. Some of our people have still not had their packages, is my understanding. They don't know what the company's going to reward them or award them with, and so they're in a very difficult position. And P&O have said that they've got access to these lawyers. They're not getting access to lawyers because the lawyers can't cope with the amount of traffic coming their way. So some of our people have still had no advice from the lawyers that P&O have put up. So they're in a very difficult position. And they're also facing this peculiar situation where all these eminent people, up to the level of the Prime Minister, are discussing their future, and QCs and professors about the law. Nobody's discussing, as far as I can see, how we're going to get these people back to work. Because this company has made flagrant breaches of the law, as just been described. They've done it deliberately, and they've factored in what they're going to have to pay for it. And they're threatening and blackmailing our people that if you do not sign this document by next Thursday, you will be out of work and you will potentially get no award whatsoever, and you have to give up all of your legal rights to take this company to task. This is absolutely outrageous. So not only is it calculating in terms of what they've got to pay, they brought into life this company, LMF in Malta, 6 weeks ago. It didn't exist. So they're chooping people to a company that doesn't exist, and they're informing people behind a brass plate in Bermuda, the Bahamas, and Malta, and Cyprus about our members' future in County Antrim. So what are you going to do? Phone up somebody in the Bahamas and say, I'm getting rid of 100 of your people in County Antrim, and not tell their representatives? The whole thing is a set-up, and the law in this country is a shambles. And the politicians and the lawyers in this country have watched over the last 30 years while not only workers have been made vulnerable, but our merchant marine has been decimated and destroyed. And if this goes the way it's likely to go, from what I've seen, we won't have a merchant navy in this country. There will be no ratings working out of British ports and on British ships. British ships will cease to exist, and British ratings will cease to exist. And that's what P&O are aiming to achieve, to kill our merchant marine and to kill our employment laws. And something's got to be done about it today. The Prime Minister said he's going to prosecute. This government has got to intervene now, impound these ships and get our people back to work. And then we'll sort out the law after.
Okay. Obviously, that's your key ask, is impounding legal action. The government seem to be doing something. Is there any other key ask that actually gets your employees back working?
Well, the key ask is that we put a safety regime and get some safety inspections that are not just superficial. I've got no faith that P&O will run these vessels safely, and maybe Mark will have some more comments on that. But we have got a desperate race by P&O to get these vessels back out on the seas. We understand they moved one of them last night to empty Hull to get people over on an empty voyage over to Rotterdam. They are desperate to get this back on the seas, and they think it's all going to blow over as soon as they've got discount prices out to the hauliers and to the public, and they think it's all going to blow over. The government must do something. The only people with power in this situation are the ministers of the Crown. They're either going to sit there and watch this happen, or they're going to get the MCA to impound those ships and not let them travel. P&O has already taken them out of the port, so they're outside your jurisdiction. So not only do they have contempt for the law, they have contempt for your house. You discussed it yesterday, and what did they do last night? Move one of the vessels outside your jurisdiction. So our ask is for intervention. I don't mind which intervention it is, as long as you stop P&O breaking the law and putting two fingers up to every member of this House and potentially completely diluting employment law in this country. What was said about...
Again, it's,
right, Carol,
we're limited in time, but I think for that, just then to ask Mark about the safety concerns that Mick was saying you'd want to comment, and also, can you maybe outline what UK companies have been complicit in this in terms of bringing in this new staff to take over? Because that's clearly a key issue as well. So Mark, do you want to...
Thank you, Alan, for the question, and I'd very much like to associate myself with Mick's comments about the situation that our members face. Now, the issue around the safety case, this has been a long-running discussion with P&O Ferries over the years. I'll take Dover as an example, because in a way it's the most extreme example, because in Dover to Calais, you're running passenger and freight vessels across the busiest shipping lane in the world, and you're crossing it at essentially right angles. That's the way it works, and the traffic is moving up and down in the separation zones. It's an incredibly dangerous situation, and you need skilled, qualified, experienced maritime professionals, both mixed members and my own members, on board the vessels to cope with that. They do 10 crossings a day, and they do 12 hours a day, 2 shifts obviously to cover the 24-hour situation, two crews, 4 crews in total. And we already know, we can already see, and they've tried it with us time and time again, they want to move to 2 weeks on and 2 weeks off. So that's 2 weeks on, working 12-hour shifts, looking after the safety of passengers and truck drivers moving the freight. So this, for us, is one of the key issues, and we have spoken to the company, we've discussed this with the company. I mean, in 2012, they conducted a research project and produced a paper with Cardiff University to look at the working patterns on board. And, you know, from my sense of that, that's where 1 week on and 1 week off is derived from, and we don't believe it's safe. In the past, we've made proposals to the company to increase the manning of crew in order to cope with a potential 2 week on, 2 week off, but the company rejected those proposals. So we have maintained, for the safety of those on board, not just our own members, but the passengers and the lorry drivers who we transport across on those vessels, that 1 week on and 1 week off is the appropriate. And for me, that's one of the key issues, and it goes to the heart of the safety case, Alan, and Mick mentioned that you've questioned me on. Now, beyond that, and this speaks really to the issue of whether these vessels can, with a new crew, or with a substantial number of replacement crew being drafted in to replace the SAC seafarers, whether they can be readied in a matter of days to conduct and reintroduce those services in a safe way. And we do not believe that can be done. There are obviously international rules about these issues, SDCW, Standards of Training and Convention of Watchkeeping Convention from the IMO. There's the International Safety Management Code, ISM code. Our estimation, our view, that actually in the scenario that we are facing, it could take months, not days, to prepare a crew to safely operate those vessels. I can see there are probably more questions, so I'll probably limit my answer to that, if I may, Alan.
If you could come back on, I'd asked about UK companies being complicit, because clearly this has been a very covert operation with P&O to spring the surprise. So what companies have actually helped them in terms of trying to restaff the ships?
Absolutely. I would highlight two in particular that I'm aware of that I believe, and the evidence suggests, have been central to enabling P&O Ferries to introduce the mass sacking of UK seafarers and replacement of and recruitment of their replacements, and that would be Columbia Ship Management of Cyprus and Clyde Marine of the UK, Glasgow, I believe they're based. There are one or two others that have been quick to deny any involvement, but some of the jobs they've been advertising look suspiciously like they are the jobs that have been vacated or that our members have been sacked from. But those two are the principal companies that I would name.
Okay, and I'm going to have to hand over to a colleague very shortly, but we heard earlier on there that the crossing from Scotland to Northern Ireland is wholly within UK waters, so therefore the minimum wage shouldn't be breached at all. What terms and conditions are P&O trying to put on staff that they're trying to, move into that crossing, and would it breach the minimum wage in the UK?
Well, my understanding is that they'd have to pay the minimum wage on that crossing for ratings,
Absolutely.
but that they will be without pension, they will be without any terms and conditions, they will be without holiday pay, they will just be voyage only, so it'll be for the hours they're on board that ship. There'll be no conditions associated with it, but we'll have to see. They will use whatever they can use, and at the minute they're desperate to get people because people are walking off their ships, is our understanding. But we believe that they would have to honour the national minimum wage. But of course, our members weren't getting paid the minimum wage. Our members were getting paid negotiated, decent terms and conditions. So any step down to the minimum wage is a dilution of what we already had. They've broken the union agreements. They're also, about companies, just very quickly, Alan, they're undermining every other seafaring company in this country. We've got good agreements with Stena and DFDS. Yeah. What are they going to do? How will they compete with this piracy on our shores? And they're really concerned about that, and we're really concerned about our members. We could end up with a race to the bottom initiated by P&O, and I think that's what it's designed to do.
Initiated by P&O and facilitated by Clyde Marine.
Exactly, and we've had it with Irish Ferries. Irish Ferries have done exactly this procedure already.
Thank you. Thanks, Chair.
Chris Lader, please.
Thank you, Chairman. Good morning, gentlemen. It's good to have you with us today. The first question I had for you is, could you confirm, to your knowledge, is this a matter for the UK workforce of P&O Ferries only, or are there other workforces in other countries that are affected? Do you know?
Thanks for the question, Chris. My union...
Sorry, this is a straightforward answer.
UK only.
And if so, where are the countries, please?
No, it's UK only.
Lovely, thank you very much. I understand that there are 786 people who've been affected by these redundancies. Could you just tell me what percentage of those 786 are RMT members and also Mark of your union, roughly?
So of those 786, about 450 are RMT members. I don't know.
Well, I presume the rest would be Nautilus members.
Okay, so maybe 60-40-ish. Okay. And of the wider workforce, those who are not being made redundant, are you aware of the number of staff that are not being made redundant? So I'm sorry, I don't know the wider workforce number.
They said it's something around something above 2,000, but that will be administrative, marketing, finance. They're not within our the RMT
Because it is the
sphere.
entire seafaring workforce.
That's very helpful.
UK seafaring workforce.
Those who have been made redundant, you mentioned just now that they were paid above the minimum wage. Were those who've been made redundant paid above the living wage?
Absolutely, yeah.
Okay.
Properly negotiated.
Yeah.
You know, there's a whole scale of salaries right up from the master, who's at professional status, to people working in the canteens.
And that's the same for, I'm assuming, on the same terms and conditions. Great.
Yeah.
Okay. When were the last negotiations that the unions would have had with P&O about terms and conditions?
I haven't got the date. It's on a regular cycle. We could have been a 2-year deal. But what I would say, we've got no beef with P&O. We're not in a dispute. We were meant to meet them on the 18th about their prospects for new vessels, which would be about new staffing. I'm assuming Mark's union was as well, new crewing procedures. Instead of honouring that meeting, they sacked all their members on St Patrick's Day. St Patrick's Day massacre, you might call it.
Yeah, but the last one, so in terms of the last negotiations, would you say what was 12 months ago-ish, or?
I haven't got that figure, but it would be on a regular cycle.
So I just wondered if both of you could confirm that at those last negotiations, P&O Ferries will have given both of your unions and the MP for Dover the assurances that those negotiations were going to safeguard the future of P&O. If you can't answer it today, I understand that because of your respective roles. We would very much appreciate it if you would write to the committee and confirm if you could have maybe consult the regional organiser, because I think this is a very important point. I've been informed by those who have an interest that actually assurances were made to the unions and to the MP for Dover that those negotiations were going to safeguard the future. So that would be really good to understand. Could I just ask, the employees affected, where actually are they based?
So for Dover, many of them are in the Dover-Kent area.
Dover, is
yeah,
it?
but the way that seafaring works and the way that it's been in decline, we'll have members from Ireland, the Republic and the North working at Hull. We may have people from Great Britain working in Ireland. But in Dover, they are concentrated around that area, but people do travel across the UK. Some people live abroad.
Yeah,
as well.
so the people who are affected by this redundancy, they are Dover-based and any other bases?
Well, they're not all Dover-based. I mean, they're based, often they work in the vicinity of the port, simply for convenience for joining the ships in their regular rotation. So there will be substantial numbers in the Dover area, in the Hull area, Liverpool, Cairnryan, Larne,
and all
Liverpool. Did I mention Liverpool, where I'm from? There'll be significant numbers.
All these bases have been affected by this redundancy?
Yeah, absolutely, all of them, yeah.
Wonderful. Could you just confirm to your knowledge whether or not staff were physically and forcibly removed from ships?
What I can confirm is that security personnel came on board in security outfits, and that our members were told they had to leave the ship immediately. They were escorted to their lockers and their cabins, because our people live on these things for 7 days at a time. So they've got their own personal effects, their part-time home. They were made to load those into plastic bags, and until they did that, they would not receive the packets containing the information about their dismissal and therefore the compensation, as they might call it. So I haven't heard of any force or any restraint or anything like that, but there was intimidation in the sense you had 4 or 5 security guards standing around individuals or groups of individuals saying you must go to your cabin now, clear out your stuff and remove yourself from the vessel.
I understand, and I'll just come back to you, Mark, in just a moment. I understand, and I referenced the BBC and the Independent, that a leaked email that was reported actually suggested a company called Interforce was engaged by P&O, and a little bit of research tells me that Interforce are handcuff-trained security professionals. Are you aware of handcuffs being used to forcibly remove anything?
No, I'm not aware of any incident. I don't know whether Nick is directly of the handcuffs being deployed, but there had been some suggestion, I think, from the company that though nobody was wearing balaclavas. Well, I have information, I have reports from my members that that's not correct. They were some wearing balaclavas.
On what ship that was the case?
I can't, but maybe I can
You'd
write
write to us and tell us. I'm sure we'd appreciate
what I would say, and I just want to follow up the point Mick made about our members live on these vessels for varying periods. I've just received this morning a photograph of the personal effects of crew that were sacked in bin bags on the deck of the Pride of Kent by skips ready to be thrown in the bin, just like the seafarers who've lost their jobs. And I'm sorry, but that's the most disgraceful thing. Yep. Beyond what happened 1 week ago this day, that's just a new low, and I'm really shocked by it.
Would you agree that this is the most extreme form of corporate mass bullying you have ever seen in your career so far?
Mick and I have been spending a lot of time together over the past 7 days, and the anger that we feel is real.
What I said?
Not anger at being with him, by the way. I've learned that he's a hell of a nice guy.
I've heard mixed things.
I'm not sure that P&O Ferries intended to throw Nautilus into the arms of the RMT or likewise, but that's what's happened.
Said is what I'm asking.
So the answer to that straight question is absolutely shocking. I've never seen anything like it in 44 years in the shipping industry.
You agree with what I've said?
Sorry.
Thank you very much.
Well, I'm an electrician and I was blacklisted from construction. That's why I'm on the railway and I have ended up in this job. And I had to take McAlpines and Kia Group to the High Court to get that settled, along with 3,000 others. So there are other examples of corporate hostility. But that made us paranoid because we couldn't see it all the time. Yeah. This is when it's in your face. This is probably the most extreme I've seen in my career. And I've never seen a reputable company destroy its reputation in such quick time.
Thank you. I just want to go on now to what staff have been offered. First of all, could you confirm that it's your understanding that all staff affected by redundancies have been told they must sign a non-disclosure agreement, otherwise there is no discussion, no negotiation, and nothing to be offered in terms of recompense?
Well, yeah, my understanding, our members have got settlement agreements, they're called, which have got non-disclosure in them. So it's at a rate of 2.5 weeks per year. Everybody's saying this is so generous. That is under the level that we negotiate on the railway and many other companies. It's not that generous. They've given them 13 weeks pay in lieu of notice because they never gave them any notice, so they have to give them that. And they've built in this, that the QC was talking about, a protective award. They've factored that in. And you have to sign that you will not take any legal cases for any issue against P&O. And our understanding as well is that you can never talk about P&O in the open at any time in the future. And if you don't do that, you'll have to take them to tribunal for the statutory award of only one week per year of service.
I think we've been clear on that non-disclosure agreement. Could you just finally, because I've got to hand back to the chairman shortly, could you just finally tell us what have the staff affected by this redundancy actually been offered by the company that you know of?
2.5 weeks per year of service. They've been given 13 weeks pay in lieu of notice. They haven't been given it, it's in the document. And a 13-week compensatory award to buy off the tribunal case. And if they don't sign it, they would have to take the statutory minimum awarded by the government at capped rates. So it's blackmail, in our view.
Could I just add, if there's time, the point made earlier that there's no rehire involved in this, well, actually the company's put it in writing. They want 91 of my members to come back. And in addition to the package that Mick has outlined, they're offering a re-sign bonus of which will be payable in 12 months' time. And if they accept that today, so there's an additional pressure on my members to sign today, no later than today. And if they don't sign by today, but sign by next week, that bonus offer is reduced by half. 91. The crewing strategy is in tatters because they didn't plan to do any of this rehire. They plan to replace everybody with Ukrainian seafarers and Russian seafarers, and for obvious reasons, that part of the plan is in. So this plan, if you can call it a plan, is Plan B.
Can I thank you, gentlemen, very much indeed for answering the questions. Chairman, I'll hand back to you.
Thank you so much. Nazgani, please.
Thank you so much. I must put on record that I am a trustee of the charity, the Seafarers Charity. Mr. Dickinson, you're a trustee as well. And my questions are to you, the two short questions, hopefully you can respond in short answers to. I'm anxious about one of the lines of question that Mr. Brown had, and I want to make it clear that I've been having some private messages or DMs from people on board the ship, and they were not made aware of where they were being sent to. They weren't aware that they were going to go to a P&O ferry destination, and there's huge anxiety that what they've been caught up in as well. So this has just been dreadful for everybody involved, and I don't want for them to feel any more anxious and frightened and threatened either. Do you agree, Mr. Dickinson?
I agree, and that's correct. I have same information I've been receiving from members.
Thank you, Mr. Dickinson. Are you also anxious as much as I am that P&O Ferries thought they could turn this around in just 10 days, considering the lack of experience and knowledge of crew aboard? Where do you think they would have come up with that number of 10 days? Do you think there were any conversations with anybody for them to be comfortable they could have those ships safe and ready to sail in 10 days?
No, I don't think anybody that knows the maritime industry or would consider themselves to be a maritime expert or a maritime professional would have come up with a figure of 10 days.
So would you agree with me that they would be impossible for them to comply with the standards of training, certification and watchkeeping, STCW, or the ICM code, the International Safety Management Code, within 10 days?
No.
You agree that it would be possible, or?
No, sorry, I would agree that it wouldn't be possible.
Thank you so much. Thank you, Mr. Dickinson.
Thank you very much. Well, thank you, Mike Lynch and Mark Dickinson, for your contributions this morning. We're grateful to both of you. We're now moving on to our third of 5 panels this morning, and we'll be welcoming Dean Beale, who's the Chief Executive Officer at the Insolvency Service, Brian Johnson, who's the Chief Executive at the Maritime and Coast Guard Agency, and Casey Ware, who is the Director of UK Maritime Services. All three of whom are with us in the room this morning. We'll just let you get comfortable. Great. And the first question is from Hugh Merriman.
Thank you, Chair. Perhaps we'll start with the Maritime and Coastal Agency, if I may, and I know that my colleague Nizgani wants to carry on. So the Secretary of State has said that you as an agency will be going in to inspect the ships from a safety perspective. Can you tell us what you've been doing so far, what you've found, and whether you consider this new crew to be safe to sail?
Can I maybe just give a little bit of context around this?
A little bit, yeah.
So we operate within an international framework set by the International Maritime Organisation, a UN agency, and every ship is flagged with a state, the flag state, and that's the state whose legislation holds on board the ship. And the international conventions lay down the accountability of the flag state. So for these particular ships, Cyprus, Bahamas, Bermuda, lay down the accountabilities for the flag state, which are the primary accountabilities around the hardware, the equipment, the manning, the experience, the competencies of the crew. Living underneath that, for each nation that a ship visits, is the port state responsibilities. That's like a safety net, in this case for the UK, to check that we're comfortable that the flag state has fulfilled its primary responsibilities. So that's the broad context for probably a lot of what Katie and I might talk about today.
So actually, in a way, even if the sort of Cypriot requirements have not been met, you can ensure that the UK standards have to be met, not just in port, but all the way through the journey as well?
It's the Cypriot standards that there are minimum standards that have to be met internationally, and the specific standards on board the ships are set by the Cypriot. By
you're only
state
looking
regime.
at safety from a Cypriot safety book perspective?
We are looking at it from the safety envelope that we would require within the UK. But
let me just be absolutely clear. So, are you looking at the UK safety rulebook and applying that, or are you actually looking at the Cypriot safety rulebook and applying that?
There are universal safety standards that have to be applied on shipping, and those are what we would apply. So those include, for example, as previous witnesses talked about, STCW, the Maritime Labour Convention, the ISM, the International Safety Management System. So we would ensure that those are being applied.
Okay, let me ask it another way around. So if they were actually registered in the UK and Cyprus wasn't in existence, would there be any difference in the type of safety regime you'd go in and look at?
Yes, there would, because we would have dual accountability. We would have flag state accountability, so that primary overview accountability for all the standards on the ship,
and we'd be looking at it from this safety fallback position, which is the port state regime.
Right, okay.
So,
all right, let's drill in now to what you've actually... So the Secretary of State's been very bold in House of Commons and said you're going onto those ships to inspect them. What have you done so far?
So the Pride of Hull, which sailed yesterday, probably is the one that we've been most engaged with. We went in, we did full port state inspections, and those cover the certification of the crew, certification of the vessel, certification of the crew includes what qualifications they've got. It would look at hardware, it would look at key safety drills, actually run through those, do those safety drills live with the crew. So it's Katie can describe in a little bit more detail if that's helpful, but essentially we'd be covering that. We covered all of that off.
So you signed off on it?
Correct.
And on that vessel, how many new crew were there? What percentage were new crew?
18 in total were new.
18 new crew?
New crew, correct.
And how many crew in total were there?
Can I, Katie,
there was
do you know?
110 crew on board, 18 were new.
Okay, right. So a small percentage. Is that the sort of percentages you're expecting, say, for example, the Dover-Calais ships? Because obviously there's a heck of a lot of people that have been, we've been told all the seafarers have been made redundant or sacked. So that's a small percentage.
I'm not sure we're clear about exactly what that situation is going to look like at the moment.
So P&O Ferries believe that they'll soon, in days, be able to move their ferries from Dover. How long will it actually take in this situation for you to fully inspect and sign off, do you believe?
An inspection would take 1 day minimum, could be slightly longer than that, depending on what's found.
Give us an example. If you've got a completely new crew, say, or you know, there's a much greater percentage, and sort of how long is that like? I mean, surely it will take you a heck of a long time to make sure that every single person who's come on board that ship, who's not been part of the ship's crew before, this is one of the most dangerous shipping lanes. Ro-ro requirements are stricter, perhaps after the Herald of Free Enterprise. I mean, surely you'll be taking a heck of a long time.
Yeah, could I maybe defer to Katie on this one? Cause
Yeah.
she can add a little bit. She can add a bit of colour to exactly what those inspections involve, which might help.
Yeah, we really want to know how detailed you can make this be.
So just to confirm for the committee, we have not actually got the port state control inspection scheduled for the Dover fleet yet. We are waiting for confirmation from P&O with respect to the crew, and so we've not got those port state control inspections scheduled. We would go on board that vessel. As Brian has said, we will inspect the certification of the actual vessel. We will inspect the certification of the minimum safe manning of that vessel to ensure that they've got the right qualifications. We will ensure that those members of the staff, and that could be hotel staff who are responsible for dealing with passengers during an evacuation, have got the necessary safety familiarisation.
Okay, can I ask you to speak up a bit?
Sorry,
some of the
my
members
apologies.
are...
So for any crew that are not operating the vessel but are responsible for mustering and escorting passengers off the vessel when there's an emergency, we ensure that they have got their proper familiarisation around management, crowd management, risk assessments, etc. So when we go on board, not only will we check in the certification, but we will do full drills. So we would put in place a complete fire drill. We would exercise those fire crews, those hotel staff, to make sure that they're completely familiar and able to evacuate those ships in an emergency. We also, for example, even drill down into making sure that those crew can take orders and can communicate instructions in the assigned language of the vessel. So it's a very heavily focused operational exercise. And as Brian has said, that can take us between 1 and 2 days. I do not envisage them taking less than 2 days. As we just said, the Pride of Hull, we were on the 22nd and the 23rd of March. As we've shown from the figures, that is a crew that is familiar with the ship, but it still has taken us 2 days to do that port state controlled inspection.
Okay, thank you. And would you speak to every single member of crew to ascertain that they know what they're doing, can understand, as well as looking at it from a team holistic perspective?
So we would watch, for example, the fire parties. The surveyors on board would watch those fire parties to do what they do. In terms of the crew members, like the hotel staff that are responsible for guiding passengers through, we would talk to them and ask them questions about what their roles and responsibilities were, so we were key that we understood, that they understand what they're required to do. For crew that were responsible for launching the lifeboat, we would talk directly to each and individual ones of those teams, ask them to explain to us what they're doing in terms of launching and preparing those lifeboats. We would then watch them launch the lifeboats, manoeuvre those lifeboats and recover those lifeboats. So it's an intensive discussion.
And you're responsible for hours of work or rest, safety management, certification of seafarers and training of seafarers. Just picking the latter up, I mean, obviously you can't just pitch up even if you've got experience, and then actually be able to operate that boat. It must take a long time to train up. They must have to go out to sea.
There's a highly structured system in STCW, which is the international standard for seafarer training, highly structured training system, and we'd make sure that people were qualified to the right level. And the idea of that system is that it can be internationally used and internationally applied on board ships. So we'd absolutely check that people were certified to the correct standards on board, as well as looking, as Katie's described, at how they perform within the drills.
Okay, and just coming back to the ship that sailed from Hull, is it the Pride of Hull?
Pride of Hull.
Yes, it was.
Did that get signed off? Did it sail successfully and you've certified it?
Yes.
You did?
Chair, can I just introduce, there's a tweet gone out breaking confirmation that the MCA have not given P&O Ferry Pride of Hull permission to return to normal operations. No row-packs means no passengers. It's our understanding that the vessel is en route to Rotterdam for replacement crew and safety drills.
So we undertook port state control.
Sorry, Katie, can you speak up again?
We undertook the port state control. It was completed yesterday. My technical manager, who leads in the North East, confirmed to us that that vessel was cleared by the MCA to sail. P&O advised us that that vessel would sail from Hull to Rotterdam yesterday evening without passengers and cargo. That vessel is due into Rotterdam, and she will then be presented to the Dutch administration, and the Dutch Maritime Administration will also undertake inspection of that vessel.
No row-packs, what does that mean?
There was no passengers or cargo on board.
But they'd have to do this again with passengers on as well, and you'd be inspecting at that point, would you?
No, we won't be inspecting
That's
again,
it.
but they're presenting the vessel to the Dutch administration before they load passengers and cargo.
And my final question is, what conversations have you had with the Secretary of State about the inspections that he feels you should be delivering and what you can do?
We've been clear with colleagues at DFT that we'll be absolutely enforcing all the port state inspections in a really rigorous way. We've been talking with the flag states as well, so we understand what Cyprus, Bermuda, and Bahamas are going to be doing in terms of inspections of those vessels, and we've had French and Irish colleagues who we've been in touch with, who, although these port state inspections are absolutely UK port state inspections, colleagues from France and Ireland also wish to witness those port state inspections. So you've
been clear, but what conversations have you had with the Secretary of State? You're the Chief Executive of the agency, he's the Secretary of State. Have you had a conversation with him or the...
My conversations have been with my opposite number in DFT, who I know has been in contact
with an official, not a minister?
Sorry, I can help you there, Chair. So following the Minister Court statement in the House on the Thursday the 17th, I actually contacted his private office to advise him that we would be inspecting all 8 vessels, and that we had agreed with P&O that we would be inspecting all of those vessels. And that we advised that if we had any safety concerns, that we would obviously enforce the regulations, and if necessary we would stop those ships from sailing. And I was sent that to Minister Courts' private office on Thursday the 17th.
Would you not have expected a minister to contact you and say, right, we want to make absolutely sure these ships are safe, you look in every nook and cranny, speak to every single person, Would you have expected that conversation to come your way?
Sorry, Chair, I should have said that email was in response from the Minister seeking my assurance that the safety concerns would be addressed with P&O.
Okay, well, I'll leave it there because others will want to come in. Thank you so much.
Thank you. Nusrat Ghani, please.
Thank you, and good morning. I've got quite a few questions. I'll try and keep them brief, and the answers can be brief. That'd be great. You talked about the inspections taking place. There is some anxiety that inspections are taking place without any passengers on board. So how are the new crew expected to evacuate potentially up to 2,000 people in an emergency? How are you going to prove that, inspect it, and authorise it, Ms. Ware?
It's a difficult question to answer. As I said, I've explained how we do the drills and the operations. It is quite normal practice for us to do it without passengers. We very rarely use passengers for safety reasons, as you can understand, for those drills. And often when we're doing those drills, there are no passengers on board. So that's not just applicable to the ferries, that's also the same for the Class 1 passenger vessels. We don't do it with passengers.
Complicated because we've got new crew in a very difficult situation. I'm now going to read out a message that was sent to me by a person that was arrived on the ship as new crew. They didn't know where they were going. They hadn't realised this is where the contract was. And they sent me a message which has given me a huge amount of anxiety. They said to me, the safety of the vessel has not been considered. The crew that I am with have no knowledge of the vessel. The ship is currently in a situation whereby the engine could stop running as the crew do not know how to transfer fuel to them. This morning, the vessel almost ran out of water. I don't want to read too much. I don't want to give the identity of the person or the ship away. How absurd is it that P&O thought that you were going to authorise these ships in 10 days? And how can you authorise these ships fit when this is information we're getting from crew on board the ships?
Difficult for me to respond when I don't know the ship. If that information was shared with the MCA and we knew what that ship would be, we could obviously bring forward the inspection.
Mr. Johnson?
Yeah, same thing. If we have the information, we can bring it forward. You know, we will apply, as Katie said, the port state control inspections absolutely rigorously. And you know, if we've got safety concerns, and our surveyors are good at what they do, if we've got safety concerns, those ships will not sail.
All right. Another message I received. The MCA will verify the vessel is safe to sail. This is from a person on board the ship. The MCA will verify the vessel is safe to sail when the ship's master and officers indicate that they are ready. And we expect a port state inspection as the vessels are flagged in the Bahamas. As the ship officers were expected, the vessels will pass initial inspection as the majority of the officers are unfamiliar with the ship. How is this being managed? How many communications are we having on board with people on the ship to give you the confidence that you can let the ships go?
So our surveyors would have conversations on board during the inspection. That's a key part of what they do. Katie, do you want to illustrate the sort of conversations that take place?
Yeah. It's difficult for us to prejudge until we get on board of those vessels, but our absolute priority is when we get on board of those vessels is to ensure that the seafarers on board are familiarised, qualified, and are clear about their responsibilities. So until we get on board, it's difficult for us to prejudge, but you have my absolute assurance that we will go in absolute detail to ensure that those crew on board are familiarised, qualified, trained, and that we are satisfied that they can operate those ships safely, and those vessels will not leave until we are satisfied that they are safe to operate.
To be clear, we are not working to a timetable on this.
They're working to a timetable. They want to be done in 10 days.
Understood.
So do you think it's going to be 10 days or 20 days or 3 months?
I don't have a view. We will do our job on the port state inspections. We'll do it well.
The Maritime Coast Guard Agency has a really stellar reputation, and what P&O Ferries has done has just undermined the reputation of the MCA. There were 3 flagged states involved overseas. Why was there not better communication with the MCA, with yourselves, for them to give you notice that they had been given notice, so you could start communicating with P&O Ferries?
We've spoken to the flag states, and they were not informed until the 17th.
Say that one more time for the record, Mr. Johnson.
We've been in communication with the flag states, and they were not informed until the 17th. That's Thursday last week.
Flag states themselves.
Correct.
That is Cyprus, Bahamas, and Bermuda.
That's correct. That's what they've told us.
And the action of P&O Ferries, I would argue, has undermined all the work that the sector, governments, and even myself when I was in the department, all the work that we're doing towards Maritime 2050, taking a decision how we manage, take care of seafarers in the UK and our relationship with companies such as P&O Ferries. What do you suggest, Mr Johnson?
I think what we need to do is make sure that the Maritime and Coast Guard Agency continues to operate with the absolute professionalism that it's known for, and our commitment is to do that.
And you take care of the flagging as well, don't you? You
Sorry,
take care of flagging as well within.
Yeah.
And doesn't this undermine flagging as well? So we've got 2 more passenger ferry companies flagged with fantastic grade A seafarers. Their business model now, they'll feel is being challenged.
Of course, we love to have as many ships on the UK flag as we.
This
as
doesn't
we
help. What
possibly
P&O
can.
Ferries has done doesn't help that, does it, whatsoever?
I can't. I'd love to have more ships on the UK flag.
Can I just ask, when was the last time you spoke to a senior representative of P&O Ferries and the last time you spoke to a senior representative of DP World?
I haven't had any communications with DP World. I spoke to the chief executive of P&O Ferries on Monday morning to make sure that we had proper lines of communication and clarity on what was happening when. So there was a Teams call I had with him, with one of his colleagues, and me with one of my colleagues on Monday morning.
And can I just for the record ask, when was the last time you were in a room with a minister providing evidence, support or guidance over this issue?
Can I do it with a Teams call rather than a room?
Correct.
Can we do a virtual room? That was yesterday.
First time?
Sorry, I thought you said the last time.
That was the last time was yesterday. When was the first time?
The first time, on this particular issue, personally, let me think back. I'm really not sure. I think the bulk of the communication's been the one that Katie had.
Thank you. I've got 2 supplementaries, but I'm also very conscious that Mr. Beale, I don't want you to feel like you've missed a morning in the sun. The Secretary of State has written to the Insolvency Service asking you to look at the notification requirements and the potential for penalties to be applied to P&O Ferries. We heard in the first panel that if P&O Ferries had not notified the flag nations with appropriate notice, so Cyprus, Bahamas, Bermuda, that is a breach of UK notification law. Do you agree with that?
I think, my team are working through all of the facts on this case, looking at the law, and, we will very quickly, I think, arrive at a determination as to whether, there have been breaches and what action could be taken as a result of that.
When will you come to that conclusion?
Well, the Secretary of State has asked for a response from us by the 8th of April, so we're working very hard. You'll have heard this morning how
All the crew will be sacked by then, and the officers.
Why does it take so long to come to a view?
We had a lawyer saying it was illegal. We had several lawyers saying it was illegal. How long do you need?
Well, there are inquiries ongoing. There are inquiries with the foreign jurisdictions that colleagues in the Department for Transport are pursuing. We need to gather all that information in. We need to...
You really don't. You've been told that they were notified on the 17th of March, and that is inappropriate. There's a breach of the law. That is established. It's what you now do with that. Sorry, Chair, with the interpretation of that breach of the law.
I mean, if we can come back to the Secretary of State quicker, we absolutely will.
I think you probably should. And just on the question of penalties, there was some confusion in the first panel about how you would calculate a penalty if this overseas notification was done inaccurately. What's your view on that?
I think again, it's really unclear. I mean, we heard this morning the complexities of the sort of different applicable laws that might be appropriate in a case where there's multiple jurisdictions. On the face of it, my understanding is that the penalty for failure to notify would sit with the jurisdiction where that requirement to notify would exist. We need to look at that very carefully. Very interesting contributions from the speakers this morning, which we will absolutely look at very carefully as well.
Okay, we have to move on, but I suggest you really all do need to move quicker than getting an answer by the 8th of April. Chris Loader, please.
Thank you, Mr. Chairman. Brian and Katie, I just want to say that from what I've heard from you today, and as someone who's worked in the transport sector for my entire career before coming to Parliament, I'm quite concerned about the effectiveness of the safety regulator from what I've heard from you today. I'd appreciate it very much if you would share with us the paperwork that was signed off for the Pride of Hull to sail. And I think certainly my colleague, Mr. Morris, and I would be quite keen to understand in a little bit more detail at a later point when you do further inspections to understand the extent to which we have confidence in that. Thank you.
Thank you. Hugh Merriman, last
Yeah, I just want to come back. So one of the issues that's been raised is the concept of moving from 1 week on, 1 week off to 2 weeks. Do you have a view, given the rostering has got to be within safety, do you have a view on whether that is normal, safe, concerns?
The key thing here is the hours of rest and ensuring that the crew, so you could have crew on board for up to 6 months, that's permissible. The key thing is ensuring that those crew have their hours of rest that are required by law. And when we go on board the vessels, we inspect those hours of rest to ensure, and they've got to be recorded. So the key thing is making sure that the crew are rested and able to perform their jobs.
Right, but do you not look at it and say, actually, from a safety, good practice perspective, these shift patterns are right, good industry standard, this isn't, it's a deviation?
It's not for me to tell ship operators what their shift patterns should be. The key thing is that they get their hours of rest.
I think it should be actually for you to tell them what their pattern should be, because you're responsible for safety, and actually if you believe that's not safe, then I think you should. Sorry, Brian.
No, it's okay. So again, this is a slightly complicated regime that we operate within. So the primary responsibilities around this are with, let's say, the ship was flagged with Cyprus, for example. Primary responsibilities.
You move the mic back over. Sorry, sure. We can't. People can't hear.
The primary responsibilities would lie with Cyprus and the ship operator to get that right. What we do then is apply international regulation and then the appropriate local UK regulation.
So that's if the Cypriots say it's safe test, is it, rather than the UK?
And if we're uncomfortable with that, we can obviously we can write to the Cyprus flag regime. But that's a slightly complicated regulatory framework that we operate in.
I mean, I'm coming to the conclusion, I'm interested in your powers, whether actually, given what I remember in terms of the Herald of Free Enterprise, that I'm slightly concerned that we're actually relying on what the Cypriot standards of safety are on the Straits of Dover. Well, let's listen to them. Because you've just said, actually, that's a Cypriot.
But it's also governed by a set of international regulation and safety.
International. I'm talking our own UK high standards here, which seems to be a bit, unless other members can completely understand it, and I'm missing the point. We're not entirely clear here whether Cyprus governs, UK governs, or whether you've actually got the best of both, highest standards of both. So perhaps answer that. Right.
So the Cyprus flag, they're responsible for setting the manning levels on board, the safe manning levels on board. What we would inspect from report state control is the working hours to make sure that they're working the necessary and they're getting their rest hours in a certain set period. I don't have to hand the exact specifics of what the working regulations, but I can write to you to verify that.
Yeah, can you write to us and just set out this hierarchy and which applies? And then the last point I want to ask you is, have you dealt with anything on the scale of this before in terms of seeing crews change such large numbers?
Never in my career.
And you have the sort of holistic powers rather than just looking at the individuals. I mean, why wouldn't you turn around and say, actually, I'm looking at this from an entire practice. It cannot be safe, and certainly in terms of days, to be able to completely change your crew and bring brand new crew on. So rather than even looking at the individual parts, can't you look at this holistically and say, this can't be safe?
We've got to operate within the powers of that port state control regime, which are all set out. We're part of the Paris Memorandum of Understanding, a group of countries that do port state inspections, and our powers are really set out within that. So we're dissatisfied with the safety on a ship, we can detain it, but it's on a ship-by-ship basis, and we have to inspect it in order to use that power. We haven't got those holistic powers that
you might actually look at it on a ship-by-ship basis and say this practice is so unheard of for us, we can't cope with this as an agency. We're really concerned about safety, we'd have
to base it on the inspections that we do when we get on board the ships and on the results of those inspections.
Thank you, Chair. I've got two final supplementaries, but I'm going to have to limit you to 1 minute question, 1 minute answer, please. Gavin Newlands.
That's fine. Thanks, Chair. It's just a point of clarification. You mentioned Rest hours, and obviously the working time regulations, etc., don't really apply here, but as I recall from my previous career, you've got different rest hours, you've got your daily rest hours, and you've got weekly and perhaps monthly rest hours, depending on the job. If you said as long as you get a 12 hours rest per day, that's fine, or is it because the way you answered the question, it sounds as if they could work for 6 weeks on and 6 weeks off as long as they get a 12 hours rest period per day. So could you clarify that?
Sorry, my apologies, Mr. Newlands. No, we don't just look at the daily rest, we look at the weekly and the monthly hours as well.
What would you be what's your minimum requirement on that?
I haven't got those details to I
If you
can
could
write
write to
and
that, that'd be great.
clarify
Thank you.
them.
Thank you, Graham Morris.
Thanks very much, Chair. In the statement on the on St Patrick's Day on the 17th of March, the Shipping Minister laid great store by your intervention, but having heard your explanation about the restrictions that apply in respect of the relevant flag, I'm less than convinced. You mentioned you'd had a number of meetings with ministers, including yesterday, some by Zoom and some in person. How frequently have you met with the trade unions, with Nautilus International and the RMT? They are the experienced seafarers and officers who know what safety systems are. If I might just say, I had a terrible experience many years ago going from Stranraer to Lawn in a very stormy sea, and I was so grateful to have experienced seafarers who were able to anchor the HGVs that were moving in that stormy sea and could have jeopardised the safety of the ship. Wouldn't it be reasonable to have discussions with the existing crews and their representatives?
I'd say, in answer to the general question, we and the RMT and Nautilus are in fairly regular contact, but we haven't been on this particular issue. They have written to us, and we have responded to the concerns that they put in writing to us, and we got another letter yesterday which we will respond to first thing tomorrow. But we haven't had face-to-face dialogue over this particular issue. We have more broadly got very good communications, I think, between ourselves and the trade unions.
Given the fact, Brian, both you and Katie have said this is unprecedented, you know, the scale of the sackings and the impact it's having in this particular sector and this operator, wouldn't it be prudent to have face-to-face meetings with people who are actually familiar with safe working practices?
I think, you know, we're very ready to be to have dialogue with RMT and with Nautilus in taking them through what our findings are on the inspections when we do the inspections. I think though that, you know, one of the challenges here is, as we were outlining earlier, is our powers are actually quite quite tightly defined. So there's actually quite limited room for manoeuvre here. We've got to do our job, and we've got to do our job very, very well and very professionally. But there's quite limited flexibility around that because of the framework that we operate within.
I understand that, but it's a critical issue, safety. But sorry, Chairman.
Thank you. Thank you to the three of you for your contributions this morning. We're grateful. We're now moving on to our fourth panel, where we're welcoming on the screen Jesper Christiansen, who's the Chief Commercial Operations Officer at Maritime Services for DP World. And in the room, we'll be welcoming Peter Hebblethwaite, who is the Chief Executive of P&O Ferries. We'll just let people join the screen and the room. Sorry, Peter, just the one next. Your name's on that one. Thank you.
I apologise.
Right, and there's some fresh water there for you as well. Okay, we'll get going. Mr. Hebblethwaite, when I was reading your biography, it seemed pretty light on your experience as a Chief Executive Officer. Are you in this mess because you don't know what you're doing, or are you just a shameless criminal?
Thank you for giving me the opportunity to come and answer questions. And actually, before I answer that question, can I start, please, with an apology? Actually, an apology to the seafarers that were affected on Thursday last week, an apology to their families, and an apology to the 2,200 of our employees who have had to face very difficult questions over the last week or so. And you may see this as a late apology, and I just want to reassure you that the reason that you're hearing this, I guess, for the first time today is because I've spent the last week in the business talking to our people, one-to-one, in person.
Why didn't you talk to them in advance in a consultation, Mr. Hebblethwaite? Why apologise after you've sacked them all?
So, the context of this incredibly difficult decision is that P&O has lost an unsustainable amount of money. And the reality is, and this is the backdrop that I would ask you please to bear in mind, is that we would have had to close the business if we hadn't.
I'm sorry to interrupt. I have lots of businesses come to my committee and tell me that, but they all consult before they make their staff redundant. You didn't. Why not?
So we thought long and hard about the routes to this, and we did consider every single option available to us, and we concluded that every single option available to us would result in the closure of P&O. And ultimately, and I haven't had a chance, and it would be great to talk to you about what this actual new crewing model looks like, but it is a fundamentally different operating model, and no union could accept
Did you ask them?
our proposal.
Did you ask the trade unions?
No.
Okay. In your letter to the Secretary of State, you said that you notified the relevant competent authorities in Cyprus, the Bahamas and Bermuda on the 17th of March. Is that correct?
Yes.
We heard earlier that that was in breach of your notification requirements to notify Cyprus within 45 days of the first dismissal and the Bahamas and Bermuda within 30 days. Do you recognise that?
Not being a lawyer,
but presumably you have access to lawyers, Mr.
Of course, and we are clear that we have not breached that law.
Who did you write to in Cyprus?
I will have to get back to you on that.
Who did you write to in the Bahamas?
I'll have to get back
Who
to you on
did you
that.
write to in Bermuda?
Let me respond.
Did you sign off these letters?
No.
Can you provide this committee with copies of them?
Yes.
Thank you. What's your salary, Mr. Hebblethwaite?
My salary is a basic salary of £325,000.
You have access to a performance-related bonus?
I have access to 2 performance-related bonus, a short-term incentive plan and a long-term incentive plan.
You think you've increased or decreased the value of P&O Ferries by your actions?
I think that P&O was otherwise going to close and didn't have a future.
And so if your employers are, might I suggest, mad enough to offer you a performance-related bonus, will you accept it or reject it?
That is, I can't tell you how far that is from my
As a
thoughts.
point of principle, will you accept it or reject it?
I don't know the answer to that. If we manage to save the company...
As a decision for you, if I'm offering you a performance-related bonus and you've just sacked 800 people, will you as a point of principle say, I'm not going to take that?
I don't know the answer to that.
You don't know the answer?
I've got to be honest, I'm not focused on that. I'm focused on saving the business and getting the 800 seafarers new jobs.
Right. You recognise that asking your employees to sign a settlement agreement means that they are withdrawing their rights for further legal action against P&O?
Yes, I do. And we are making extremely generous payments as a result of that. £36.5 million. We think the largest maritime settlement arrangement in history. There will be people receiving upwards of £170,000, but actually probably, I don't know, very few. There will be about 40 who will receive more than 100,000, but most importantly, actually, is at the other end of that scale where we have capped the minimum. So if somebody started work with us in the last month or so, actually we've said that we will pay a minimum of £15,000. So we've uncapped the top, and we've absolutely said as a minimum we will pay £15,000. We recognise we did a very, very difficult thing. We recognise money isn't everything, but we do want to compensate people fully, and I absolutely want to be focused on getting them all new jobs.
Thank you. Mr. Christensen on the screen, please, from DP World, the owner of P&O Ferries. Are you going to sack Mr. Hebblethwaite for gross misconduct?
I couldn't imagine that we would do that, no.
And did you sign off on these proposals?
So, DP World has been informed on a continuous basis on the situation in P&O Ferries, obviously as the shareholder.
Did you sign
and
off?
We have also been informed of the evaluations that P&O Ferries have had in terms of different routes to making this business viable and sustainable, and eventually also being informed and supporting the decision that was then eventually taken.
Thank you. And Mr. Hebblethwaite's just said, Mr. Christensen, that P&O Ferries is about to presumably go immediately bust unless you sacked 800 members of your staff. Do you agree with that assessment?
So the business, P&O Ferries, has definitely lost a lot of money over the last few years. No business can sustain that forever. The business was not viable in that situation or under those conditions. So a number of things have been evaluated, and eventually this model was then chosen as the only route available as an alternative to ending up in liquidation or
It's very strange, Mr. Christensen, because lots of other businesses in trouble follow perfectly legal routes, but you seem to be having no regrets about the decisions taken by your business. The last question from me, whilst I've got you, Mr. Christensen.
Mr. Chairman, with all due respect, having no regrets, you have not heard me saying that we have no regrets. We acknowledge.
Would you like to express
also, as DP World, we acknowledge the pain that this has caused to a lot of people, employees, seafarers, their families, etc. So you're not heard me saying that we do not acknowledge that pain.
Well, I'm sure the families are grateful for your regrets after sacking them, Mr. Christensen. My last question for you is, I understand that DP World owes £146 million to the Merchant Navy Ratings Pension Fund. When are you going to pay that?
I don't know if the 146 is the right number. I have no knowledge of that.
I understand it is, and I also understand that you
I'm
paid
not.
£147 million sponsoring a golf tournament, so it should be affordable for you, shouldn't it?
May I add a point?
Please.
So the liability for the pension fund, as I understand it, is a P&O liability, and we have an agreement, and we will honour those agreements to make those repayments.
Thank you. And DP World will be giving you the money to do that, presumably, given you don't have any.
Well, sadly, the reality is this was a very difficult step that we had to take to make the company viable and profitable, at which point we will be able to honour our own commitments.
Very good. Andy McDonald.
Thank you, Chair. Mr. Christensen, you talk about this being painful and difficult. Your company paid out $376 million in dividends to shareholders in the last 2 years alone. Couldn't you use some of that money to treat the workforce at P&O with some decency and dignity? Don't you think that was your duty?
So DP World has taken absolutely zero dividends out of P&O Ferries for the last many years. We have, on the contrary, we have kept on supporting the business over and over again, supporting the existence of that business for a number of years with hundreds of millions of pounds.
Okay, without regard to the welfare of the workforce. Mr. Hebblethwaite, did P&O have a duty to consult the unions in good time over the redundancies pursuant to Section 188 of the Trade Union Act of 1992?
So there's absolutely no doubt that we were required to consult with the unions. We chose not to do that because we believe...
You chose to break the law?
Because we chose not to consult, and we will and will compensate everybody in full for that. I recognise that this is a really
When you get in your car and drive down the motorway and you see the 70-mile-an-hour sign, do you say that that's not going to apply to me, I'm going to do 90 because I think it's important that I do that? Is that how you go about your life?
No.
No, it isn't. Did the collective agreements in place between P&O and RMT and Nautilus provide for negotiation over such matters as redundancies?
Sorry, could you rephrase the question?
You had collective agreements with RMT and Nautilus. That provides for negotiation over such matters as redundancies. You've done it before. Why didn't you do it? What was the moral justification for you not doing that?
Okay, so these are very extreme circumstances. In order to answer that question fully, can I explain the difference between the operational model that we previously had and the one that we are moving to, so that you understand how fundamental a change it is, and that helps me explain why we had to take the route we had to take. Would you allow me to do that?
As the Chair has already pointed out, there's many companies that have difficulties. They obey the law and they consult with their members through their trade unions. You haven't done that.
We've moved from one operating model to another.
And you haven't escaped the law of this country. You've still got to do it within the legal framework. You can't just decide that you're going to absent yourself from the legal system of the United Kingdom.
So it was our assessment that the change was of such a magnitude that no union could possibly accept our proposal.
Oh, you're
And
right
on
about that,
basis-
Mr. Hamilton. I've never heard such farcical answers to a series of questions. Okay, can I move on, Chair? In selecting UK employees, most of whom will be UK nationals or residents, when you selected them for dismissal, P&O has evidently discriminated against them on grounds of nationality. What was the legal justification for doing this?
To be clear, actually these weren't exclusively UK nationals. They were largely UK nationals, but this was a group of international employees.
So what are the new rates of pay to be offered to the new crews? How much are you paying them?
The two models are very different. So to answer that question is a bit more complicated, if you can allow me the time. The previous operating model required us to have 4 crews for every ship on Dover-Calais. The new operating model requires us to have 2 crews and pay people when they work. So they're assessed in slightly different ways. The answer to your question is that the average Jersey seafarer was paid £36,000 and will receive £46,500, so a year and a third in compensation. So that's part of the answer to the question. The second part of the question is, what are the hourly rates of pay for the new model? So the average hourly rate of pay is £5.50. On top of that, there is a pension contribution, there is food and accommodation.
Pension contribution? That's below the minimum wage.
And then, sorry, can I make a couple of points, please? So on the routes that are international routes that are governed by ITF standards, we are paying above ITF minimum wages. And on our domestic route, which I think was referenced earlier, Larne, Cairn, Ryan, where we are governed by national minimum wage, of course we are paying national minimum wage.
And so the seafarers aboard the vessels that are leaving Dover, the replacement crew, they're going to be paying on average, paid at the rate of £5.50 per hour.
Yes.
That's below the national minimum wage of this country. How do you reconcile that?
Where we are governed by national minimum wage, we will absolutely pay national minimum wage.
Oh.
This is an international seafaring model that is consistent with models throughout the globe and our competitors.
Could you live on it, Mr. Hebblethwaite, £5.50 an hour? Could you sustain your lifestyle on £5.50 an hour? No, you couldn't, could you? Why do you expect people who've got such responsible jobs to be able to do that? How do you expect them to be able to feed their families and pay their bills at £5.50 an hour?
So there's a couple of very, very important points here.
One's called gas, one's called electric. Those are the important points. They can't pay their bills.
One couple of important points, please. The seafarers who join us are international professional seafarers with all the international certification. These are experienced seafarers.
I'm going to move on. I've got to move on. Can I ask Mr. Christensen? Because Mr. Christensen, on your website, DP World, you say the DP World respects and supports the human rights of our employees. You go on to say, amongst other things, in relation to collective bargaining, DP World respects the laws and labour practices for each country and will not hinder the development of means for independent and free association. How do you square that with the experience of your company, P&O?
Sorry, the line was breaking up.
Well,
one more time, please. The latter part of the question.
Well, you'll be familiar with your own human rights statement, which adheres to the Universal Declaration on Human Rights, the ILO Declaration on Fundamental Principles and Rights at Work, the Guiding Principles on Business and Human Rights, and yet you've completely trashed them in this. They're not worth... Are you going to take this down off your website because it's an insult?
So I do not believe that it's an insult, and I do not believe that any of what we have done, P&O Ferries,
you need to ask the 800 people that
is in conflict with any of that.
Of course it's a direct conflict. We hear some ridiculous things, but for you to say that those principles still obtain when people have been summarily dismissed without no notice whatsoever and replaced by people on £5.50 an hour is an outrage. There's some NDAs here, Mr Hebblethwaite. Are you going to rescind those? Because, quite frankly, the members of this committee think this is absolute thuggery and criminality. You're behaving like gangsters to blackmail people into this situation. Will you withdraw those NDAs and let people have the freedoms that we all enjoy?
I'm assuming you're talking about the confidentiality clause that's in the severance agreements?
Gagging agreements, yes.
It's a standard confidentiality clause, and actually it's there to protect both sides.
Oh God. Okay, I'm just getting into the end of this. Let me just ask one more. Why did you employ a private security firm to remove seafarers from your vessel? Were you pleased with what you saw on our televisions, on social media, of people with handcuffs marching up the gangplanks onto these vessels? Why did you do that?
So I don't think you have seen pictures of people in handcuffs, because actually it was very clear we did employ a security firm of professionals, and actually and the reason for that was to keep our people and the ships safe. And the reality is, coming out of this, is that we didn't get a single incident throughout the day. We kept everybody safe, everybody secure.
Mr Hebblethwaite, people were terrified. They were going about their work in the ordinary way to see people invade the ships and start ordering them about, telling them that they had to pack their bags and go. Is that a humane way to treat loyal employees who've given you such incredible service? Is that decent?
So the security team were there to keep the ships and, most importantly, the people safe at a time that was genuinely a stressful time for them. It was our assessment that was
stressful because you made it stressful. You were the author of the stress.
There's no doubt that when people hear that they are losing their job, it is extremely stressful, and we wanted to keep the ships and, most importantly, our people safe.
Thank you. Thank you. Gavin Newlands, please.
Thank you very much, Chair. I think just to come back on this, can you perhaps clarify for the committee and to everyone watching and to the P&O workers, what employment law provisions have you breached?
So we have not consulted, and for that we are fully compensating people for that in full upfront.
And how much is the business going to save each year by sacking the crew summarily and employing agency staff?
So this entirely different model is about half the price of the previous model.
About half the price?
Yeah.
And you said the average wage of the seafarers in the new model. What's the lowest minimum lowest hourly rate in the new model?
$5.15.
The lowest?
Yeah.
You said in answer to Mr MacDonald the average was £5.50. Is everyone from the bottom?
$5.15.
£5.15?
Yeah. So $5.15. The average range is from $5.50 to about £6, depending on exchange rate. But I gave you the low end of that.
£5.15. And do you think that's a fair wage? Do you think the international maritime laws in terms of wages are fair and sustainable, or as many people now see it as modern day slavery? What would you say to that? So
the rates that we're paying are in line or above ITF minimum standards, and it is the operating model that the vast majority of operators across the globe work to. So this is the competitive standard.
I appreciate that, but do you think the ITF standards are fair and reasonable? Is that something that the world, perhaps in light of this, that your action are going to have to look at and address?
I think that they're negotiated rates of pay, and therefore those have been successfully negotiated on both parts.
I'm not sure how successful it was on the workers' part, to be perfectly honest. Over the last year, have P&O or indeed DP World broached with any government minister or official that you may be changing practice at any point? Not an official notification of what you did last Thursday, but any hint or indication as to what you might be doing or looking at?
So I can share my understanding, but I wasn't at the meeting. So I believe that on the 22nd of November, the Secretary of State for Transport was visiting Dubai, and at Expo he met with some of the DP World exec team, and as part of a broader ranging discussion, which included ongoing investment in the British economy, the subject of P&O Ferries was brought up, and that we would be needing to make some changes to our business this year. Beyond that, I can't confirm. All I can say is that at that point in our planning, we hadn't finalised our plans, so I doubt any conversation went further than that, but I don't know.
I appreciate that the final plans hadn't been made, but that's quite an important point you've just raised. Could you perhaps look into that and provide the committee with more detail on that meeting? Because the fact that the government perhaps were warned that something was afoot months in advance is quite an interesting point the committee might want to know. Can I turn my attention to Mr Christensen? Has any other DP World company ever undertaken such an action? Is this standard practice for DP World, or is this a first?
I don't know, to be quite honest. In the period of time that I have been occupied with DP World, I do not think that there has been anything similar to this, but we've also not had a situation in the company or in the businesses that is owned by DP World that is similar to the one that P&O Ferries has been finding itself in.
Well, just for clarity, could you perhaps again write to the committee just to confirm that indeed this is the first time a DP World company has undertaken this sort of action? And for the impact on DP World, are you concerned what this might mean for DP World and its relationship with the UK government moving forward? And as we understand it, you have an agreement in place with the government with regards to free ports. Do you think this will have an impact on that agreement?
So I am responsible for the maritime activities in DP World and cannot speak for what that means to other parts of the business. But I can assure you, as we have done, both Mr. Hebblethwaite and me in this session, that we have taken a lot of consideration to the decision that was taken here. P&O Ferries board have been coming to DP World, consulting with us on this. We've been informed. We have made everything that we could to make sure that all proper care was taken. We have done everything that we can do to make sure that the people affected are being looked after. So, yeah, of course, we have taken into consideration that this decision could have some kind of impact beyond P&O Ferries, but still we have had given P&O Ferries the support for that decision under the prevailing circumstances.
Did you essentially force P&O to take this decision, or was it just a broader, they must save X million?
Sorry, one more time, the line was breaking.
Did DP World force P&O to take this decision?
So P&O Ferries is a business in its own good right, and the P&O Ferries board will have to take the business decisions for P&O Ferries that it has to take. So DP World is interested and obviously focused on making sure that our businesses are viable, whether they are in the one corner of the world or the other. But at the end of the day, the operational decisions in P&O Ferries is P&O Ferries to decide upon.
Okay, thanks. And back to Mr. Hebblethwaite, did you anticipate such a reaction?
Could I also just confirm Mr. Christensen's point? This was a P&O Ferries board decision. We, of course, required funding and support to do it, but ultimately this was a P&O Ferries decision. This was not forced on us or even suggested to us by DP World. But, sorry, your question was?
What was my question again?
Were you expecting this reaction?
Yes.
Oh, sorry, I do apologise.
Thank you, Mr. Bradshaw.
The reaction to this has been extremely strong. There's no question about that, and I do regret that, and I recognise it. I really, really do recognise it. But there was no P&O without the changes that we needed to make. So we anticipated this would be very difficult, very controversial.
And lastly, for me, for a hand back to the chair, are you not concerned that these actions will actually bring about the end of P&O rather than save it?
I think we've got a tough job to do now to rebuild the business, but I think a P&O with a future and a P&O that is able to be competitive, pay its own bills and offer the customer service that is required has a much better chance.
Thank you. I'm afraid I have indications for questions from literally every member of the
Sure.
committee, so
Sure.
apart from you. So I'm going to call you all, but please just keep your questions and answers tight and keep it moving, please. Nusrat Ghani.
Thank you. Mr. Hebblethwaite, is it accurate that you said that the Minister was informed on the 27th of November?
22nd
22nd of November?
is my understanding.
Which one? Which Minister?
The Secretary of State for Transport. If I misspoke, I apologise.
You have a minute of that conversation?
I don't know.
Thank you. What a mess. What a mess. So P&O Ferries have been operating since 1844, and then one Zoom meeting, you trash it all. 800 people now on the dole, and you're now trying to clean this up, having ruined the reputation of P&O Ferries and undermined everything we're trying to do in the sector, even encouraging people to come forward and become seafarers. And you were saying that you've got a number of regrets. I've just been sent a picture of Pride of Kent, where I believe crew that you've dumped on the dole, all of their bits and pieces are in bin bags. Why have you done that? Why don't you fix that right now? Why don't you fix that right now? Make sure that the people that you fired have some dignity and get hold of the items that they've left behind. Can you fix that right here, right now?
So actually, I've already taken steps to see what has happened there, and I have been assured, so we will find out the specifics of that photograph, but I have been assured that the team are taking personal responsibility for returning people's belongings to them.
Take them out the bin bags and give them back to the people they belong to. Give them some dignity.
The bags that people were given was on the day, so they could have something to carry off the possessions that they could carry. The possessions they're otherwise taking, we're returning to them, and we're employing companies to do that and box them up and return them.
So you would have heard from the early session the anxiety that we have that the MCA will be able to credibly allow the ships to sail, and you've come forward to say you've got a number of regrets, and we would have hoped that maybe you're going to be treating the new crew a little bit better. I've had messages over the weekend from people on board, and this doesn't give me any confidence you're going to treat the new crew any better. So the message say the replacement officers were not informed they were replacing crew being made redundant. We were told that a new company is being set up and that it could possibly be from Glasgow. No representatives from P&O were present when they were on board the ships to brief the new officers, and we've had no direction from P&O as to next steps to take. You must understand the fundamentals of managing a passenger ferry service. Surely you've been told and briefed. This gives me no confidence that the new crew have confidence in the leadership, or even your leadership, or whether they think the ferries are competent to sail. What's going on? It just seems to get worse every day.
So, a couple of things. We did employ a professional security firm to talk to people. We had to talk to them all at the same time. You mentioned a Zoom call. So the nature of this crewing model is that at any one time, half of our seafarers were on board and the other half were at home spread throughout Europe. And so we wanted to inform everybody at the same time. So people on board, where at all possible, we spoke to them in person. The people who were not and who were at home and spread throughout Europe, we had no option but to invite them to a Teams meeting. There was a live meeting. Yes, it was scripted, but it wasn't pre-recorded. I think that's important. And then we followed that up with one-to-one phone calls where we could get hold of them, and of course we followed up in writing.
Replacement officers.
Yes.
Why have they not been given one-to-one meetings? Why have they not been spoken to by P&O leadership, P&O Ferries leadership?
So we've been on board. In fact, we've had some of our fleet management team and our ships support services have actually been living on board the ships to help with the familiarisation and the training. I've been on board. I've spoken to the new crew and the new officers. We've had 51 officers ask for the paperwork to join the crewing management company and come back and help rebuild the business.
Can I ask why you didn't come forward to the department to ask for more advice or guidance to try and get you out of the situation you felt that you were in?
So we felt it's important that we were able to have a viable ongoing business, and we needed to move to a competitive operating model that is recognised throughout the world and our competitors also use. It was a very difficult step we had to take, and all of my regrets are around the impact it's had on the individuals, but I do recognise it is a step we had to take. We didn't talk to really very many people at all because of the nature of, we knew it was going to be controversial and it needed to be confidential, because without that confidentiality we simply wouldn't have been able to implement this incredibly difficult decision.
Did you change anything, knowing what you know now, what you did last Thursday?
That's a really, really difficult question. The business would close. The business was not viable. This is the only way for us to save this business, and we have moved to a model that is internationally recognised and widely used across the globe and by our competitors. I would make this decision again, I'm afraid.
Wow. Just one quick clarification before I go on to another member. You said, Mr. Hebblethwaite, to Ms. Garney that you had a discussion with the Transport Secretary on the 22nd of November.
I didn't have that. I wasn't part of that discussion, but I believe that that a conversation was had in Dubai at Expo on the 22nd of November.
With who?
With
No, but who was the Secretary of State having a conversation with? If it wasn't you, who was it?
Transport. Sorry,
so the Transport Secretary had a discussion with somebody in Dubai.
Yes.
Who?
Some senior execs at DP World. I don't know who. I wasn't there.
Mr. Christiansen, who had that conversation with the Transport Secretary in Dubai?
I don't know either. I was also not participating in the.
Presumably, you can find out for us and let us know.
Yes, and I think that Mr. Newlands asked us to do that.
Thank you.
But can I please reiterate? At that point, our plans were nowhere near finalised, so it is unlikely that that conversation would have had any real substance to it, I suspect.
You didn't participate.
Okay, Graham Morris, please. Thank you.
Thanks, Chair. You may recall, Mr. Hebblethwaite, previously, this is a joint committee with the of Transport and Vice. There was an invitation from Transport to come to our committee. We were looking at COVID support during the pandemic, and there was a change in the chief exec at the time, and that wasn't possible. But that was arising out of the COVID support the company received, and I think the freight grant as well. It was around about £15 million. But it was also because a number of redundancies had been announced, affecting a number of ports where P&O Ferries were involved. What was different that you were prepared to respect UK law and consult with the recognised trade unions on that occasion, and yet weren't prepared to do it on this occasion?
So it's quite a lot that was different, but it's a good question. So during the COVID pandemic, during the height of it, we anticipated it would come to an end in the early part of 2021, and we anticipated that we would be able to restructure the business with limited redundancies, and that was a reasonable conversation, and we absolutely consulted with that. The COVID pandemic has gone on much longer, and we now need to fundamentally address the viability of this business. Otherwise it closes and an additional 2,200 people lose their jobs. And so in this situation we will need to change our operating model, and on that basis, and I know the reaction I got last time, but it is true that we assessed that given the fundamental nature of change, that no union could accept it, and therefore we chose not to consult, because a consultation process would have been a sham, and we didn't want to put anybody through that, and we are compensating people in full and upfront for that decision.
Do you have a name for this new operating model, the new operating model that you're applying with the reduced crewing and so on? And
it's called multiple things. People call it agency crew. I talk about running our crewing through a crewing management company.
I've heard it rather cruelly referred to as the skeleton crew model.
I think it's really dangerous that I let that lie. These are very, very experienced, fully certified, professional international seafarers.
I just
ask them decent wages then.
I know time. Yeah,
on 50 an hour.
I know time's really short.
I'm going to have to move on. I'm so sorry. I'll call you at the end if I've got time. Paul Howell, please.
Thank you, Chair. I just find it bizarre that as a business you've chosen to break the law as a business decision. It's incomprehensible to me. P&O are now a laughing stock. I don't know whether you'll find that it's your Gerard Ratner moment in terms of a business. You're seen as contemptible by any right-minded people as to the way you're running your business. I really don't understand how you think that the government or anybody else is going to want to engage with P&O or DP World in anything with any faith or any trust that you're going to do anything that you say that you're going to do in future. With hindsight, do you really think this is a sustainable way to have your future? Do you think that this is a viable way to run a business?
I think that we weren't viable before, and I know that if we hadn't made radical changes, the business would have closed. And I know I keep repeating it, and I apologise for that, but genuinely that would not have been 800 redundancies with substantial severance packages. That would have been 3,000 people losing their jobs, and the impact on 3,000 people throughout multiple nationalities.
Mr. Christensen, you made the comment earlier that it was your part of the business that was involved in this, and that I got the impression that the broader DP World assessment wasn't fully considered into this. And it was, you talk about not being associated to the teams that are involved in the free ports type agendas. Do you now regret that? I mean, it seems to me as though what you've done is you've exposed your entire business to contempt, not just the risk of P&O going down. Do you have any regret of that, even just from a pure business strategy point of view?
Let me once again stress that this decision was also not an easy one for us to sign off and support in terms of P&O Ferries. Of course it wasn't. I think the commitment of DP World to the UK economy, about billions of pounds of investment in terminals and free zones, etc. That commitment, I think, is second to none. I mean, we have not invested more funds anywhere else outside of Dubai than in the UK. And the commitment to P&O Ferries, and therefore also a British icon, somebody mentioned back to 1847. Yeah, that the commitment is also a part of us being very observant to, in this case, that we have done everything that we could to make sure that people were taken care of. It was also noted a little bit earlier that the packages that have been offered to the affected employees, that they are funded out of DP World, and they are. And therefore, that has been very important to us to make sure that we did everything we could to support the people who were affected by this. That is also a commitment that we do to make sure that that doesn't make the decision any easier, but at least we have taken it very seriously to try to make the impact as bearable, if I can use that word, as possible.
Just to wrap it, Chair, and really just I think it's bizarre that you think that the right way to do it is to buy your way out of following UK law, and I think that's just something that'll come back and bite you. Sorry, Chair.
Thank you. Simon Jupp, please.
Thank you. Mr. Hebblethwaite, you've said in this session that what you've done to 800 working people, including people in my own constituency, was necessary to save P&O. Stinks. You might have avoided financial bankruptcy, but in the minds of many customers, you are morally bankrupt. What have you done to the brand?
So, no question, the brand has taken a hit. There's no question about it. I don't deny that. And we did something that was incredibly difficult and we knew was going to be controversial. But we now have a business that we can rebuild and grow. A competitive, modern business. I am very, very sorry to those 800 people and their families. But otherwise, the whole business would have closed and we would have lost a British icon and 3,000 people would have lost their jobs. And that is the backdrop.
The icon's mired, though, now. The icon's mired in this disgraceful behaviour. How will you recover your brand?
It's no longer an icon.
It's not a British icon anymore. It's not something we're proud of.
Well, we have a future now. We wouldn't have, we don't have to close the business.
You really think you've got a future? Do you think the customers will want to buy tickets from you knowing what you've done?
I really do. I think it will take a while. I do think that there is a hit to our business, and I am, again, incredibly sorry. But we do have a future. We do have a business that is now competitive, that now can meet the customer needs and can pay its bills.
Are you hearing from your booking systems that people are cancelling tickets, cancelling their trips? Yes? To what extent?
Well, we're not actually on sale, obviously, because at the moment we're not.
But in the
sailing.
future tickets that have already been bought for things and trips that people were looking forward to, have they cancelled them as a result of this?
Some people certainly have, and it's the reduction in bookings is different on different routes, partly because people buy with a different in a different pattern on different routes. So on Dover-Calais we have taken a particularly large decline, but it's because those bookings tend to be made 2 weeks ahead. On something like Hull-Europort, where people make bookings 3 or 4 months in advance, we're still maintaining strong levels of booking, as we are on Larne Ken Ryan.
Okay, thank you, Simon. Chris Loder, please.
Thank you, Chairman. Mr. Hebblethwaite, thank you. I have 3 very short questions for you.
One, ideally.
They're ultra short. You basically sacked employees and outsourced employment to agency staff, I think that's the correct assumption, to approximately a third of your workforce. That is predominantly also to UK citizens. Could you just tell us briefly why you haven't done that to French citizens or Dutch citizens, why it's just UK citizens?
So the vast majority of our crewing model was employed through Jersey. We have, I mean, it might be double figures of French employees, and we have very few numbers of Dutch employees. So this was about...
It's easy to sack them here, that's why.
Yeah. Okay. Where is your office based?
I have an office in Dover and I have an office in Hull.
Could you just tell us why your ships are flagged in Cyprus, Bahamas and Barbados when they sail from the United Kingdom?
So this predates me by some way, but there was a change made, and I believe that the move to Cyprus was to do with maintaining our commitments to the French tonnage tax that we have.
Okay, thank you. And very briefly, I'm assuming you risk assessed this enormous change in your business, and I'm assuming you had a safety risk assessment. Could you tell us what the result of that risk assessment was, and whether or not you actually shared it with the Maritime and Coast Guard Agency?
So one of the reasons for engaging this security firm was to keep everybody and our ships, but most importantly everybody, safe. And I have to restate, and I think it's a really important point, that with all the rumours out there, the reality and the facts are that we didn't have a single incident.
Can I just be clear with you? I'm talking about your ability, your licence to operate. This is what it's about. Have you risk assessed the enormous change, and have the MCA signed off that risk assessment? Because in my opinion, I cannot understand how you can continue to operate ships safely in a way where you completely remove your workforce and the MCA have not signed that off. And I'm sorry I didn't ask the earlier witnesses that question specifically, but I don't think that's been signed off.
So let me just confirm a couple of things for you. We engaged with the MCA before the 17th of March. We engaged with them first thing on the 16th. Please let me finish.
The assessment is the question. Please.
So, okay, so specific thing, I don't know the answer to that, let me find out. But can I just reassure you about...
Finally, I'm sorry, sis, and Chair, I'm just about to finish, I apologise. But do you mean to tell this committee that the Chief Executive of P&O has not signed off a safety risk assessment for massive change in your business? Am I right in saying that?
All of our team have been on this. I haven't seen the risk assessment. I will get that back to you.
I hope the MCA are listening to this, because this is outrageous. I cannot believe that you can maintain your position, sir. I'm so sorry that you have signed off such enormous change and you have not directly seen the safety risk assessment. Mr. Chairman, I'm going to hand back to you. Thank you.
Thank you. Alan Brown, please.
Back to employment law. This is done under UK employment law. Could you do that under French law or under law of the Netherlands in terms of employment law, this type of mass sacking?
I haven't explored that, so I don't know the answer to that.
Yep.
I'm not a lawyer, I'm afraid.
And at no point you've taken advantage of more lax laws in the UK?
So this was not a UK, the intention here was not the UK, the intention was to move from one operating model to another, as I hope I've
Return to that, thanks, yeah.
Thank you. Ben Bradshaw?
Sorry, clarification on that. You have Dutch and French-based staff.
Yes,
who
very
have not
few.
been treated in the same way.
Correct.
So.
But in fact, to be clear, they are a very small proportion of our overall crewing model.
So why haven't you treated them in the same way?
Because this was about addressing an uncompetitive and unsustainable crewing model that we have from our Jersey-based crew.
Doesn't answer the question. Doesn't answer the question.
And then there was one final question from Graham.
Thanks very much. We're looking for a remedy here, and the option that you've gone for, the model that you've gone for, must be hugely expensive. The recruitment costs, the specialist security firm, suspending operations so there's no revenue, the costs of redundancy of the loyal workforce. Are there any circumstances, perhaps the threat of an unlimited fine, that would cause P&O Ferries to think again and reinstate the workforce?
As I say, the business was unviable and unsustainable and would have had to close had we not made this incredibly difficult decision, and I'm genuinely, deeply sorry to those people affected and their families.
The answer is no.
The answer is, if we went back to the previous model, we would have to close the business. It is not viable.
Thank you. Mr. Hebblethwaite, at the beginning of this panel, I asked whether you either didn't know what you were doing or whether you willfully broke the law. You said to this committee today that you willfully broke the law. You chose not to consult, even though you know you should have done, but you decided to pay people off with compensation in order to break the law. Does that not give you concern that you're in breach of your legal obligations as a company director under company law?
So as I say, I completely hold our hands up, our hands up, that we did choose not to consult.
That's quite amazing, isn't it? You're coming to this parliament and putting your hands up and saying you willfully chose to break the law. Believe it?
We did not believe that there was any other way to do this,
No
and we
other way
are
than to break the
compensating
law.
people in full.
Okay.
Oh my God.
I'm sorry. I'm afraid we've run out of time, but Peter Hebblethwaite and Jasper Christensen, thank you for your time. We're now going to change the chair in order to start the ministerial session. I'm told I therefore need to suspend the session just for 1 minute. Order, order.
The proceeding is currently suspended. The proceeding is currently suspended. The proceeding is currently suspended. The proceeding is currently suspended.
Order, order. We now have a final panel before us. It's the ministers and officials. Can I just quickly ask them to introduce themselves? Start with Minister Courts.
Robert Courts, the Maritime Minister.
Minister Scully.
Paul Scully, Minister for Labour Markets in this regard.
Warren.
Mike Warren, the Labour Market Director at Bays.
John Connell, Deputy Director, Maritime Operations.